Welcome to today's program titled Managing Cross-Border Sexual Harassment Investigations. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to Matt Banham. Matt, you may begin.
Thank you, everybody, for joining us. So good morning and good afternoon. We're anticipating that this webinar will last about an hour. I'm Matthew Banham. I'm based in Seyfarth's London office, and my practice focuses on global cross-border corporate investigations. And I'm pleased to have with me a great team today, which are our international employment partners. We have Ana Cid, a Spanish lawyer based in New York, who covers Spain and LATAM. Dave Baffa, a US lawyer based in Chicago, who's one of many partners in the US who covers employment investigations there. We have Sofia Bargellini, an Italian lawyer based in Milan, Pete Talabart, a UK lawyer based in the UK, and Lawrence Harvey Wood, a French lawyer based in London. So a little about Seyfarth Shaw for those of you who are not as familiar as others. We are an award-winning domestic and international employment set of lawyers, and we provide the full range of contentious and non-contentious employment law support to our clients, both domestically and across the world. Our investigation practice works closely with our employment colleagues so we can seamlessly navigate and run complex workplace investigations, sometimes involving criminal and regulatory issues, and that's aimed at our multinational and domestic clients. So this brings us neatly back to our topic today, managing cross-border sexual harassment investigations. We're going to spend a short amount of time looking at the various sex harassment laws for employers across some of the key jurisdictions. We'll then touch on some of the key jurisdictional differences employers will face when investigating these types of allegations. And we'll put that all into play by spending most of our time today talking through some workplace scenarios. We've tried to cover off those questions sent in already by you, but we won't have time to answer any questions that come through the Q&A function today, but please keep them coming and we will send our answers to you after the event. So moving forward, I'm going to move on to the jurisdictional comparative law slides that we have here. So what I intend to do, and as you will have seen, we've got a selection of the key laws that are set up per jurisdiction. And don't worry, you'll get a copy of these slides after the event. But let's take some of the key points that arise here in turn, if we may. Pete, turning to you first. I can see there in the UK, there's now a new duty for employers to prevent sexual harassment in the workplace. What are some of the initial steps that employers need to be doing to protect themselves from such a claim?
Thanks, Matt. So this is new, and it's an interesting development in common law legal systems, almost a civilian duty to prevent, as opposed to what we're normally thinking of in common law systems as a duty of care. And employers in the UK now have a duty to anticipate when sexual harassment may occur and take reasonable steps to prevent it. So if you've ever been involved in something like a health and safety risk assessment, where you go around the physical and hypothetical places where employees or employees and third parties may interact, you really have to think about where there are likely trouble spots and in what situations harassment could potentially occur, and take those steps to prevent it. If sexual harassment has taken place, an employer should take action to stop it from happening again. And employers are under this new duty to take reasonable preventive steps against sexual harassment, to encourage cultural change, and where it's necessary, reduce the likelihood of sexual harassment occurring. There are a number of government publications that we can direct you to if you want more information about this new duty. Guidance for employers on developing the appropriate plans and policies has been published by a governmental body called the Advisory, Conciliation and Arbitration Service, otherwise known as ACAS, and our Equality and Human Rights Commission.
Thanks, Pete. So look, turning to Italy then, Sophia, do we have a similar duty over there?
Thank you, Matt. Yes, we have a similar duty in Italy. It's not a positive obligation to prevent sexual harassment, as this is more a general obligation, a general principle under Italian law, to take all the necessary measures to protect the physical integrity of the employees and their also psychological well-being. So it's more a broad obligation that we have to take all the necessary steps and all the necessary measures to protect employees from the health and safety side, which involves also sexual harassment, of course.
Perfect. And Lawrence, how's it all working in France?
Comparable. The short answer is that, like in Italy, there's a general obligation on the employer to protect the health and safety, to do whatever is necessary to that effect, health and safety of employees. But there is also in France, in the Labour Code, a specific obligation on the employer to take all necessary steps to prevent sex harassment, to stop it if it is carrying on, and also to apply disciplinary sanctions to employees who have committed harassment.
Got it. Just sticking with you for the minute then, Lawrence, I can see on the screen there that in terms of the actual definition of what amounts to sexual harassment, one of the key words there is repeated.
Mm-hmm.
What does that mean in reality? What amounts to repeated behavior?
Well, it is a requirement of the primary definition of sex harassment in the French Labour Code, that it's repeated behavior, which means two or more things happening. Now, that can be by a single person committing repeated acts. It can be by two or more people committing together, collectively, repeated acts in concertation or at the instigation of one of them. There is a further limb of the definition, however, where there is no need for any repetition, and that is basically where the behavior amounts to applying serious pressure on the victim with a view to obtaining a sexual act. So in that case, there's no requirement for repetition.
Okay, well, maybe we'll explore this a bit more in the scenario as we move on, but it sounds like potentially one less serious isolated event here of sex harassment wouldn't qualify under the French law. Is that right?
Absolutely right. Yeah.
Got it. Anna, then, the sexual freedom laws in Spain have seen some changes in recent times. Is there anything there you think that's important to sort of identify to the audience today?
Yeah, thank you, Matt. So it is true that the obligation to prevent harassment, sexual harassment and harassment on grounds of sex was already there as a result of the equality law, but there has been some recent development with this new sexual freedom law that is not commonly known. And the reason is because this law that has been pretty controversial is commonly known as the law of only yes means yes. Has been controversial on the interpretation of other more criminal aspects, but it includes obligations for employers that focus specifically on promoting working conditions that prevent the commission of crimes on, in grounds of sexual violence. And it established some obligations for the employers to have measures to prevent sexual violence, to distribute best practice codes on sexual violence, and also to have a specific training designated to prevent this sexual violence. So this is, again, in place since 2022. There were already a kind of a group of obligations that arise as a result of the equality law that has been there for a while, but as I said, not so well known because this law has been controversial for other aspects.
Well, I'm glad we know more about it now. Let's move to the next slide, and let's go back to the US, Dave. So any key points here you wish to highlight, maybe in view of some of the policies coming out of the new administration?
Thanks, Matt. Title VII, which is the sort of statutory underpinning of protections against sexual harassment, doesn't contain the word harassment. Instead, it was the U.S. Supreme Court, I think in 1986, that sort of defined um, sexual harassment as sex discrimination under Title VII. And so our laws as it relates to sexual harassment and the prevention of sexual harassment is largely born out of court decisions. And what's interesting about that is that in light of the new executive orders that have been distributed by the administration, while I think sexual harassment is still safe grounds, there's been, as you may know, a lot of pullback against gender identity and against and the administration specifically has declared that there is only two genders, male and female, and it represents a real pull away from what our courts and the EEOC has historically viewed as constituting sex discrimination under Title VII, which is gender identity or sexual orientation discrimination. Those things have long been thought to also be forms of sexual discrimination, which is prohibited by Title VII. But we see some pullback now. The EEOC is taking down regulations and guidance along those lines. We just saw a few days ago, Iowa changed its law on its protections for transgender status. And so it's quite a bit of the rubric that's a little bit under attack in terms of the way that Title VII is being defined and interpreted in the law. So we are in a period of flux, I would say, here in the U.S.
Certainly flux and fast moving. It's definitely a space we're going to have to keep an eye on for sure. Anna, Mexico and Brazil, that's another area that you cover as well as Spain. So any points here you wish to draw out and highlight?
Yeah, so very, very high level. Just to mention that similar to what we've heard for Italy and France, this is regarded in the context of a health and safety prevention obligation for the employers. And there are sets of obligations in both countries. In Mexico, we have this NOM 35 that regulates, the psychosocial risk factors that have to be prevented by the employer and have a set of measures to address those, and that includes sexual harassment among them. And then particularly for Brazil, there's a regulation that provides the creation of an internal commission to prevent the harassment in the workplace. And we see these in other countries in Latin America, like for example, Colombia would flag it's a country that also has a set of obligations to have a commissions, a committee to prevent sexual harassment, to have a reporting channel, to address any concerns, and to monitor and investigate any complaints.
Perfect. Well, we'll come back to see whose laws apply when in the scenario. So let's move forward, if we may, in the slides. So to the next slide, there we go. So what we've done here to help everybody who's joined is we've done a sort of comparative table of some of the key issues that are going to come up when you're considering an investigation of this nature. And we've tried to align them next to each other so you can see where there's differences, crucially, between the different jurisdictions to make that easier for you. Now, I'm not going to focus on each of these boxes at this time because a lot of this we can cover in the more interesting scenarios, but hopefully you'll find it a useful tool to come back to in the future. But I will pick up on a few points here now because I think it's important we focus on them. And so one of the key areas that always comes up in these sorts of issues, and it's very complex at times, is the issue of privilege. So with that in mind, let's go to the country which often causes the most headaches, or certainly a number of headaches, and that's France, Lawrence. How can a company avoid generating disclosable documents in a jurisdiction where privilege in the way that we perhaps understand it in the UK and the US is just not recognized?
Yeah, thanks, Matt. And I mean, the short answer is you can't avoid it. I mean, you can, the usual practical precautions, like, in the course of preparing an investigation report, obviously you can limit circulation of successive drafts, that type of thing. But the key point I would say in practice is that in the event of litigation in France, so if company dismisses the accused on grounds of committing sexual harassment, and you end up in a French labor court being sued for unfair dismissal by that individual, the company will not have any general disclosure obligation. So broadly, as employer, former employer, you produce whatever documentary evidence supports your defense, and you don't have to produce evidence in your possession that doesn't help your case. Now, there's not a 100% guarantee you'll never have to produce documents that you would rather have kept to yourself, because it is possible for the plaintiff to apply to the Labour Court for a specific order. You must disclose the following documents, such as pay slips of comparator employees, if we were talking about a discrimination case. But that's pretty rare, and I certainly wouldn't expect, in a sex harassment case, that the employer would have to disclose meeting notes, that kind of stuff, the sort of documents that you generate in the course of running an investigation for a few weeks.
And would that also mean then, in circumstances like this, perhaps where it's complex and clients have perhaps instructed external counsel, communications between external counsel and in-house lawyers would also remain secret, if not privileged, so non-disclosable?
So,
well, I'm sorry, please go ahead.
no, you finish, Lawrence, please.
Sorry, I was just going to say, in France, but the rule that's usually cited as being somewhat akin to legal privilege is essentially a rule about professional secrecy obligations applicable to external counsel. So they do not apply to in-house lawyers, because in-house lawyers in France cannot be registered as an avocat, as an attorney. But if I were advising a client in France, I would have a strict deontological obligation to keep strictly confidential any client information that I've received regarding the investigation.
Got it. Anna, how does it work in Spain?
Very similar to France. So the outside counsel or external counsel would be considered under this obligation of professional secrecy in the context of providing the advice. And there's a debate on whether in-house counsel would be covered or not. And latest opinions are like it might be covered, but not very clear so far in Spain. And in any case, it doesn't cover the whole context of the investigation. So having outside counsel copied in the communications might not make the whole investigation privilege, but similar to what we hear from France, normally the employer would just produce the documents that benefits the defense, and it's not very common that they are obliged to share all the documentation that they have in the context of the investigation. It would be more like maybe the claimant asks the court to provide any document that they know the employer has and that is relevant for the litigation, and the court might accept or refuse. So we might see situation where the investigation report or some document that has been provided in the context of the investigation has to be filed in litigation, but generally that is not, the company or the employer would decide what documents they want to file for their defense, and the same would do the employee or any other claimant part of the litigation.
That's really helpful. Look, I'm just going to bounce in Pete here, because I think there's an important distinction, isn't there, here now in the UK, listening to what's going on in Europe, that as I understand it, the reality is that things like meeting notes with interviewees is potentially disclosable in the UK. Is that right?
Yeah, I think it is. I mean, look, we always try to cloak everything as much as possible under the moniker of legal advice privilege. The common law privilege approach in the UK is quite similar to what it is in the United States. I think you call it attorney work product. But in the UK, what someone else will also try to do is use data protection legislation. Basically, an employee has a right to make something called a subject access request. I want everything that you've got on your servers about me. And again, you would resist the disclosure of privileged documents by saying we're not going to give you privileged stuff. But that gives the employee a kind of a second kick at the can, as it were, to obtain all of the information that that they want to obtain for the purposes of a pre-litigation fishing expedition. We can have some very colorful arguments about whether taking meeting notes, as an example, was a document that was created for the purposes of taking legal advice. And, you know, we always take a robust position that it is, but it's not a position without counter argument.
Got it. Okay, well, let's move forward then in the deck, if we may. If we turn to slide 10, you can, I say slide 10, the next slide. So looking at timing, looking here, it's quite clear that we've got some limitation periods for people to comply with. Let me just go to Sophia, if I may. So timing is critical to an investigation. We can see that you need started as soon as possible, but then there's a distinction between the disciplinary procedures. Sophia, can you talk us through the differences and the issues around timing?
Yeah, yes, of course. Yeah, the main problem here with Italian law is that we are a civil law country. There's no law ruling investigations. So we have law for every single aspect of employment and unions matters. We don't have any law ruling investigations. So investigations are not part of our culture, basically. While we have a very strong rule on disciplinary procedure, and what's important here in Italy is that we keep the two processes very distinct, because they can't be merged in any way in my country. So how we consider the investigation. The investigation is a fact-gathering process that at the end gives the company an overview of what happened and how much evidence we have, how many proof we can have in case we decide to proceed with what here in Italy is a second step, which is the disciplinary procedure. So when the company receives, what happens in Italy is that the Italian company normally receives an inspection report from the US, and then the Italian entity evaluates whether there is enough ground to proceed with the disciplinary procedure. The real main point here is that there's a general principle under Italian law and under Italian case law to promptly activate the disciplinary procedure as soon as the company is aware of what happened. So sometimes investigations take time to be run, and when the report arrives in our desks, we then discover that the company, in general terms, so it can be the group, was aware of the fact maybe several months before we activate the disciplinary procedure, and this could not be considered prompt from Italian case law. So we tend to solve this issue by saying that we finally knew about the fact in its entire overview only when the investigation was closed. Sometimes it works with Italian judges, sometimes it doesn't. But the reason why I'm saying as soon as possible is because we should start a disciplinary procedure against the accused person as soon as possible after we are aware of the fact.
That's really helpful. I suspect there's a similar approach in Spain, but I can see there's more prescriptive limitation periods. Anna, what are those?
Yes, and I like to flag this because they're pretty short. So the limitation period to impose disciplinary action, so to take a disciplinary action, sorry, it's 10 days for minor offenses, and these are calendar days. So it's like every day, not excluding weekends or public holidays. 20 days for serious breaches, and then 60 days for very serious breaches. So in the case of you want to terminate an employee for this gross misconduct or disciplinary action, then the maximum, since the company knew about the facts, so they learned that there was this breach, they have 60 days to act. And then we have a similar situation to what we see in Italy. The discussion is, when did the company knew about these facts? So sometimes the strategy to do an investigation is basically to win some time. Some courts might not agree, and they think that it's a strategy for the company to delay the process, and that isn't justified, and therefore the penalty, the sanction has expired. So that's why we always recommend to carry out the investigation as quickly as possible. If you have sufficient facts to conclude that there has been a breach, then start the disciplinary process, because you have the risk that the court might consider that the company already knew and that the investigation doesn't suspend this statute of limitation periods.
That's really helpful. Just to clarify then, are there any exceptions to enable the limitation to be extended? What, for example, if the complainant is sick in hospital for 2 weeks through no fault of anybody's? Is there anything like that that gives you some more time?
It would, if the testimony of that complainant is basic to get all the knowledge. So like the company cannot reasonably know about the breach until they discuss with this employee, this complaint, and the employee that's making the complaint, and therefore until you talk to them, then you don't have that full knowledge to apply the investigation, to apply the disciplinary action. The other one is when we argue that these are continuous breaches, which is like this has been extended over time. So it's not, we don't really have to look at the 60 days before the penalty. We have to look about the last 2 years. There should be breaches over the last 60 days, but it can be like you can bring a longer period if there has been a continuous breach. But again, subject to proof in the litigation.
Got it. Makes sense. Okay, let's move through the slides. Let's look at the next slide. So just so everyone on the call can see, we've set out some of the key issues around whether you can record or and how you record the interview, as well as some of the issues around reviewing emails and phone communications, which we all know are fraught with difficulty. But we'll explore that again in a moment's time. If we look at the next slide. Again, issues that come up time and time again. I won't ponder on those now because we're going to deal with them in a moment. The next slide, please. And this is the last slide dealing with our comparative issues, Works Council and interim work measures. Now, there are some important points here around Works Council, but I'm going to leave this for the moment, looking at the time that we have. And I'm sure we'll be able to weave into some of our answers how Works Council become involved, if at all, during the scenario. So let's move to the scenario and keep that on. So I'm going to leave that on now while we talk through the questions, but as you won't have seen it, I'm going to read it out and you will have it before you. So a US corporate hosts a Christmas party for senior management at its London office. Key individuals fly in from various jurisdictions, including the USA, Spain, Italy, UK, and France. Just happen to be all the lawyers we have on this call today, some of whom later attend an off-site after party. 2 days after the party, an HR executive in the US receives a call from Jamie, a senior manager based in Spain, claiming sexual harassment by Alex at the party. Specifically, Jamie said that Alex, having kissed and hugged other staff, had tried to give Jamie a kiss on the cheek and pretended not to hear Jamie's protests. Alex also tried to kiss and hug Jamie at the after-party drinks at a local bar when other staff from the France and the US office were also present. Alex is Italian, but based in France, and he sits on the company's executive board for the EU. The morning after the party, Jamie received a work email from Alex, which said, "Thanks for a great night. Hope to see you soon. Kiss, kiss." Alex also sent Jamie a message to her personal phone. "I'm heading back to France next week. Would you like to meet again this week?" Smiley face wink. Jamie wants to raise a formal grievance, but is concerned of retribution due to Alex's position in the company and has asked you not to share this with anyone else. What should you do? So, Dave, coming to you, what should the HR executive in the US be thinking of doing next when they receive a complaint like this?
Well, there's, of course, in the United States, in particular, when someone comes forward with a complaint or a concern and asks that it be kept confidential or kept private, there's always the awkward conversation, or ideally would be the awkward conversation that's not an option for an executive in the United States. Hopefully, this company has a robust sort of global anti-harassment policy and protocols for investigating claims, and that would include making sure that the executive that received the complaint knows where in the organization to escalate the concern, to kick off the investigatory process. Very little of the conduct here occurred in the United States, so my colleagues here will have lots to say about that, I'm sure. But in terms of the obligations of this U.S. executive, keeping this confidential is a non-option, and so you have to find, ideally, the executive finds a delicate way to explain to Jamie that is compelled by operation of the company's policies to raise her concern and assure her that she will not be retaliated against.
And does she have the option then to retract the complaint if she feels that it's going to be investigated more openly?
I mean, not really. Now, again, so much of this conduct occurred outside the United States. Maybe it's a matter of what you can get away with, but in general, the company would be at some risk to pretend like they didn't hear this complaint or to have it be retracted. That's not really an available option.
Got it. Well, just keeping with that point, if I may, does anyone else on the call say that Jamie would have a choice to revoke and therefore prevent the company from investigating further? If I see nobody chipping in, so I assume that everyone's in the same position. Therefore, the company can't unhear what it's heard, and it's going to have a look into this a bit further.
Yeah, I might go a half step further, Matt, and say, given my comments earlier about the positive duty that employers have in the UK to prevent harassment, if they didn't take, well, I mean, I guess this is an issue potentially in any jurisdiction. Jamie decides not to continue with the complaint, something else happens along the same lines, and then the company has let this happen and has had constructive knowledge that there is potentially a problem, ignoring for the moment Dave's point about whether this conduct is actually problematic or not. So because of the obligation to prevent harassment, I think in the UK, it's even more fraught with peril for an employer to not pursue this actively.
Okay, Pete, just keeping with you then, sort of more broadly and wearing a sort of a wider lens here, do you think there's any value to the US looking to try and start cloaking this in privilege? You touched on this earlier. Do you think this is that sort of scenario where privilege should be applied at this early stage?
Well, you know, there's the textbook answer of lawyers, which is try to retain privilege over as much as you can of everything, and then you can always waive privilege afterwards. Employment investigations and claims tend, at least in this jurisdiction, tend to get a little bit more straight to the point, and there isn't really so much dancing around whether something is privileged for the purposes at least of understanding what the complaint is. So if she's gonna go ahead, you investigate it. Whether that's something you would ever want to assert privilege on, you know, is probably unlikely. Where privilege can become more significant is if the investigation takes you outside of employment law into criminal law or regulatory breaches or whistleblowing, that sort of thing. Then you might want to have a think about protecting the lawyer's product more overtly with a cloak of privilege. But you know, I think on the employment side of this, on these facts, get stuck in right away.
Okay, so can I just ask a question to everybody then? Does anybody want more information or feel like it'd be beneficial to HR to ask some more questions before starting an investigation? Can this be resolved without going into a full formal process, do you think?
Well, I'll start while everyone's thinking. Look, one of the options here on these facts is for HR or somebody else to say to Alex, look, we you know, there were complaints made, whatever the rights and wrongs of the complaint, that this is not conduct that is tolerated by the company, and it can't happen again, with whatever disciplinary threat is relevant to the jurisdiction where the employee is actually employed. So you can have a think about whether this can be ended with a warning to all concerned. But again, even in the UK, I'd be a little bit worried about ending it there because of this ongoing duty to prevent harassment. I interpret that as an obligation to understand harassment. You can't really do that in this case without investigating what actually happened. But I'll leave it to others.
I'll just jump in on that for France, if I may, because oddly enough, you need to be really careful in France not to be appearing to issue a formal warning to Alex, because that means it's the end of the matter. You have sanctioned once, so you can't dismiss them later once you've investigated. You can't do apply any other sanction later on if that was a disciplinary warning.
Okay, that's a good trip to keep in mind. Anna, turning to you then, Jamie's making the complaint, based in Spain. Is Spanish law going to apply here? What's your view?
Yes, I would certainly want to apply Spanish law, at least to be compliant with Spanish law in the context of the investigation, because Jamie is the one that has raised the complaint, and any future responsibility for lack of activity, for not complying with the obligations. And we've seen that there's certain obligations that the employers must have in terms of harassment or sexual harassment, like having these protocols or training or reporting channels. So if Jamie in the future says, well, you know, I reported this and the company didn't do anything, and they didn't have the protocols, and they didn't activate whatever investigation or take any measures, then that's going to be subject to Spanish laws, and the obligations under Spanish law will be looked at. So I would certainly, like, even if the investigation is carried out in the UK or France, because that's a place where the accused is based, Alex is based, I would also look at complying with the Spanish laws for Jamie's side, because any potential future claim from Jamie is going to be looked at in Spain.
Okay, what about you, Sophia? Obviously, Alex is from Italy. So what's going on here? Is there any likelihood that's going to apply, that Italian law?
I don't think Italian law would apply to this case. because even if he's Italian, but he's based in France, so I suppose his employment contract is ruled by French law, which brings Italian law out of the matter. I don't think Italian law can enter in here, so I don't think he may have ground to, in case he's then disciplined and dismissed, he may have ground to claim against the dismissal in front of Italian judges or based on Italian law protection. So I wouldn't say that the law ruling the employment contract would be the one I would look at.
Okay, then. So that leaves you, Lawrence. It seems like he's based in France. So if we're assuming his contract of employment relates to France as well, how's he going to fare here?
Well, it seems to me the key points here are Alex is employed in France. So in order to be best positioned to take action against Alex, if that's the decision once you've investigated, you need to run the investigation in a way that is compliant with French law considerations. And just keep in mind, there's also a victim, Jamie, who is based in Spain. Is that right? So look at Spanish law. Are there any particular Spanish law protections for the victim that we need to keep in mind? But I would say, perhaps oddly, that seems to be somewhat secondary to, running investigation that allows you to take action against Alex.
And with an international employment lawyer's hat on, I might just add one thing. We understand Alex is Italian but based in France. We have assumed, I think Sophia said it, that the contract of employment is a French one with the French company. It is something that you want to check. Often when multinational companies assign somebody from one jurisdiction to another, they keep the original employment contract and send them to the second jurisdiction by way of an assignment letter. Technically, in this case, if they've done that, that might very well keep the Italian employment alive. And it might actually give Alex options to bring claims under the laws of either Italy or France. And I've seen one of these that actually had a similar scenario where somebody had rights under the laws of French law or Singaporean law. So it is, when you've got multinational workforces, if you think that there are always going to be some rights that attach to the person that relate to the place where they perform their services, and as well to the substantive jurisdictions applicable to the victim and the substantive jurisdictions applicable to the place of where an incident occurred, you can look at something that seems reasonably simple, and it actually turns out it can be potentially more complex.
Well, that's certainly looking this way here. And it seems like, Dave, that US policies, how would you see them relating to if they were consistent or inconsistent with some of the approaches that are having to take place in Europe? How are you going to manage that?
On these facts, although we might presume that this U.S. corporation, created a global anti-harassment sort of protocol and process, would obviously have to be mindful of some of the watch outs that have been described in the jurisdictions where the incident took place, where the people are located. But for the most part, I think this company's process would probably have sort of a U.S. overlay in terms of its thinking. Having said that, there's not really a much risk of nothing really here attaches to the U.S. other than the receipt of the phone call from the executive. And so there's not much that's implicated here under U.S. law in particular in terms of liability or et cetera. I would think the liability would attach for the most part outside the United States. I suppose unless the executive failed to act or didn't report up the violation.
True. Okay, well, let's look at the behavior. I'm conscious we've got 15 minutes left. So, well, one of the questions we got asked, no, if we stay back in the other, thank you, yeah. One of the questions we got asked was about local custom and culture. And I'm just wondering whether anybody feels here that let's just focus on the behavior at the party, the initial, the hugging and the kissing, or in this particular instance, the kiss on the cheek. Um, does Alex have any sort of defense here that he can rely upon to say, oh, this is just how they do it in France, or this is life in Europe? Anybody?
I think if I may jump in there, I would say my thinking is that the key point is that the definition of sexual harassment under the French Labour Code does not involve what the intention of Alex was at all. It's about the effect on the victim, violation of dignity or creating a hostile, intimidating situation. So on the face of it, his intentions, the cultural dimension are completely irrelevant. But with that said, I think in front of a French Labour Court, those considerations clearly are potentially relevant to deciding on the level of sanction to be applied. Yes, sexual harassment has been committed. That could be the conclusion of the investigation, the fact-finding part. But then what is an appropriate disciplinary response? I think these considerations are relevant.
Yes, and from the Italian perspective, I could tell you that in our country, it would be unlikely that a judge consider a kiss on a cheek as sexual harassment. And in my experience, I can tell you that judges evaluate, in case the employee, of course, is dismissed and files a claim to court, a judge would evaluate the facts, not only the feelings of Jamie. So what the person accusing the other, so in our case, Jamie, is feeling is only a part of the evaluation that an Italian judge would make in understanding what actually happened, how strong was Alex's behavior, for example, and if this can be considered as sexual harassment. And under Italian law, I would have some doubts.
Okay, that's good. Look, so let's just moving on then to the investigation process. We're going to come to interviews. Now, Sophia, I know in Italy there's a real sensitivity about when is the right time to interview the respondent in a matter like this. Can you just talk us through what that is? Because it is a unique point, I think, to Italy.
Yes, yes, it's really linked to what I said before. So there's no law ruling investigations, but there's a strict disciplinary procedure ruled by Italian law. So and one of the main principles ruling the disciplinary procedure in our country is that misconduct can be charged to the accused person only once. And it must be in writing in the disciplinary notice that starts the disciplinary procedure, which means that any previous interview during the investigation could be used by the accused person when later he is disciplined to say, oh, in reality, you charged the first time orally during the investigation, or even in writing during the investigation, because you asked me to answer to your questions, to your emails, and then when you started the real disciplinary procedure, this is in breach of Italian law and Italian case law principles. So our suggestion is always our Italian lawyer suggestion on how to deal with investigations is also always to try to wait and not to interview the accused person during the investigation process if it's feasible, if it's possible, and to wait and only not actually interview him or her during the investigation, but wait until a disciplinary procedure is formally started.
Thank you. So look, I just want to deal with this question as well in short order. Suspension. Does any jurisdiction here not have the option to make an interim suspension of Alex from the workplace? Or are there any other issues we should think about that are unique to your jurisdictions you want to highlight?
I mean, not that it's not permitted in Spain, it is, although it's not foreseen in the law. So it has to be justified only in those circumstances that the presence of the employee in the workplace would really difficult the investigation. This employee could destroy evidence, could pressure other employees to testify or not to testify or say one thing or the other. So in those cases, yes, only for a limited time. And it's very important that the communication is clear, similar to what we've heard before. It's clear that this is not a sanction. And I've seen this in Mexico and Brazil as well. You can do that, but it has to be very clear that the suspension is with pay, and this is not already your penalty. You're not being terminated. This is just a measure to investigate, to look if there's something, and then we will come back to you and let you know what is the outcome. Maybe nothing happens, or there's a disciplinary process after that. So that's kind of how I would flag it for Spain.
Quite similar in France, but also it's not an automatic right that you can suspend anyone whilst you investigate their conduct or the allegations against them. You're only allowed to do it in France if the allegation is of conduct so serious that if it were true, it would merit immediate dismissal without notice. So a risk there is the employee says, suspending me was completely disproportionate. It made my colleagues think I had done something truly terrible. You owe me damages for harming my reputation.
Got it. Okay, well then let's move on, if we may, to case study 2. In terms of the use of remote interviews and the access to legal representatives, that's set out in the table above that you can look at at your leisure. But I think the reality here, and everyone will be pleased to know, is that with these cross-border matters, no jurisdictions prevent the use of remote interviews at this stage to gather information or in person. So you don't need to be flying lawyers all around the world to talk to these people, and that will be something of a relief, as well as the access to legal representatives or support people. We deal with that in our chart. So let's move to case study 2, as we may, because the scenario has moved forward, as have we, with nearly just shy of 10 minutes left to go through this. So what's happened now in January 25, so into the new year, companies going through a restructuring. Jamie's been impacted as one of those and has been notified for redundancy. You, being the person in HR in the US, have received an angry call saying, why is this going on? She hit all her performance targets and believes the only reason she's been selected is because of her earlier complaint that she made around Alex's advances. And Jamie has said she's going to now file a complaint with the local authorities. Dave, back to you, if I may. What are the steps that should be going on now in the US? What should people be thinking about? Should they be getting nervous and worried?
So I certainly, even if this is an employee in Spain, and there may not be an obvious way for a claim to be brought in the United States for what's alleged here, but the complaint came through to the United States, and just from of course, the overall integrity of the company's policies and processes, you know, this is a big deal. I mean, retaliation, of course, is in the United States, retaliation claims tend to be the most troubling, because you can use the proximity of events and the background allegations to argue that that was the real reason why someone was selected. Obviously, there's some things to look into here to know whether the decision maker knew about the prior incident or was involved in the prior incident. So there's much to uncover, but you would want to make sure that there's not an actual claim of retaliation, or frankly, even an impression of retaliation as part of this process.
Then, so whose laws are going to apply here, Anna?
Spanish law, for sure. I mean, if this is Jamie's complaint under employment contract is under Spanish law, so yeah.
Okay, and so Pete, well, Harry, before I move to Pete, maybe I'll just bring in Lawrence for a minute. Does the proximity of the incident and this complaint and the restructuring project impact the validity of what's being said here, do you think?
I don't see why it should, and apologies if I've misunderstood your question. I mean, it seems to me, if Jamie were employed in France and were making this complaint about retaliation, basically the employer in France would want to be in a position to prove that the decision to dismiss under the RIF was taken quite independently from the prior complaint made by Jamie. And if you were in France, you would have statutory selection criteria to decide which employees would be dismissed under the RIF. So you'd have that framework to show, look, this is why she was designated. It has nothing to do with her complaint.
Got it. And Sophia, do you see yourself getting involved here from an Italian perspective?
Yeah, well, social criteria would apply also under Italian law. So I should give the same answer as Lawrence. But in my experience, I could tell you that an employee complaining for sexual harassment against someone in a higher position and then dismissed due to a RIF a couple of months later would be certainly ground for the employee to file a claim against the dismissal, seeking reinstatement, claiming that that was a retaliatory dismissal. So even if then you have to prove, the company would have to prove social criteria and the application of social criteria, but I would see a high risk of losing the claim in it.
Really helpful.
I think an interesting related point about burden of proof, and maybe this is similar in other EU countries, provided Jamie simply provides elements suggesting that she's been harassed, then the burden of proof is on the company to prove that the dismissal decision was justified. So it's not she that has to make the burden of proof in that case.
Correct.
I see. Is that the same as well, Anna, in Spain?
Yes. So when there's this allegation of harassment, I mean, the thing is that the employee will have to kind of bring signs of this connection. And when those signs are there, and the sign might be just filing the claim, then the company has to demonstrate that there are grounds for redundancy. Objective dismissal is called in Spain, and those have to be strong grounds to contest these retaliation claims. So this has nothing to do with the retaliation. There are objective grounds that affect this position, not this employee, the position that is being made redundant, and therefore those things are totally separated. But it would be difficult because the bar on what is considered a redundancy ground, so a fair objective dismissal, is really high in Spain.
Pete, can I just bring you in just before the end? We've got 2 minutes, but does Jamie's complaint have to be dealt with as a grievance, or can it be dealt with during the redundancy consultation process?
Well, certainly if Jamie was in the UK, I would not want to conflate the two. But look, I would say this about any jurisdiction. I think that if you're doing a global RIF and you've taken advice without going into the plethora of laws in every country about how you make a fair selection under the local RIF laws, ideally Alex has not played any part in the decision to dismiss Jamie, because we know that there's bad blood between the two. Ideally, any of these decisions are taken not just by one person, but by 2, 3, or 4. So we can say demonstrably we have a record of the factors that we took into account. You know, that should be relatively easy to, if proper procedure has been followed in Spain, that should be relatively easy to present to Jamie to say, look, this has nothing to do with anything. But I wouldn't mix the consultation up with the issue of how was the decision arrived at, I would probably run them both at the same time and try not to delay the consultation. But I'd be on the phone to Anna, you know, every hour and a half probably to say, look, are we doing the right thing?
Look, that's perfect. Thanks, guys. I think that's been really, really helpful, and I hope you found that very informative. And those case studies have brought to life some of those really interesting trips and traps you may find when managing one of these cases across borders. As you can see, there's the CLE credit, the very important, valuable credit you'll want. Look out for that number. There it is on the bottom right. As well as looking out for things, please look out for our second webinar in this series, which is going to focus on the same issues, but with an APAC focus. So that's going to be coming out in April. You'll be pleased to hear, for those tuning in the US, that it's going to be pre-recorded, so no one needs to get up very early or stay up extremely late at night to hear from our team over in the APAC regions, including Australia. So thank you again for joining. Those who have sent in questions, I apologize we've not dealt with them now, but we will come back to you, I promise, with those answers in due course. Thank you.